on peace and security. And the article outlines the commitment of partner states to cooperate on issues related to peace and security. And my chairman to into motion or to put into practice that cooperation. That's when we see the coming up of that memorandum of understanding for the two states to cooperate on matters relating to security and cross-border crimes. Therefore, we also refer to this court the authority that my brother and senior colleague, Councillor Kwago, alluded to, the one of Amar, Awad, Umar, and 10 others. And my Lord Chairman, that's a very good authority, because it clearly highlights the role of states that are parties to the East African Community Treaty. And if I may, on page 70, page 71 of that judgment, my chairman, under paragraph 30, if I may read verbatim, states that we also observe that East African Community Treaty was domesticated in Kenya, Tanzania, and Uganda. In Uganda, Parliament enacted the East African Community Treaty Act of 2002 by virtue of statutory instrument number 29 of 2005, the East African Community Act Commencement Instrument 2005. It came into force apologies, I think I misplaced the paper. But the argument I'm making is that there indeed exists an arrangement between the two states, the two partner states, that is Kenya and Uganda. This one was confirmed by authority that was clearly and well cited by my senior colleague, though with blood interpretation from his side. But be as it may, my Lord Chairman and honorable court members, we submit that indeed the laws were followed. In other words, in the absence of the extradition treaty between Uganda and Kenya, this law applied squarely on both countries. Madam Chairman, also, and that one would not really need a reference to interpret, otherwise it would be a waste of court's time. Madam Chairman, on the other issue, which issue issue 2, and my senior colleague earlier alluded to it and submitted on it, but maybe to add something that is that might be important. we really rate all the authorities that were provided to us by our colleagues, and two things are cut across in all those authorities, and my colleague Gorpo talked about it. There is a recent ruling. This one you may not need to refer to the Constitutional Court, and that ruling was very clear, staying the execution of the Kabaziguruka case findings. It is as plain as that. You don't need to refer to court that interpret this or try with civilians. It would really be absurd, very absurd. And my chairman, further on that, we also confirmed that indeed the decision, the authority that was cited by Steel Council Lukwago, the one of Abdunur Semuju aka Minana, the issues that had been raised in Kabaziguruka case were the same issues that were raised in Minana, and he can testify, he argued it. So, my Lord Chairman, it would be defeat of justice. And not only that, but also wasting court's time to now also apply to stay the execution of Minana. Though there has been an appeal, we are aware, and Council Kwago is also aware that there has been an appeal against the decision of the Constitutional Court. And we are yet to know the hearing dates. But, Madam Chairman, we submit that we base the trial of civilians in this court on the decision or the ruling staying execution, the decision of Kabaziguruka. And therefore, in this matter, Minana cannot really suffice. It can't. As I conclude, Madam Chairman, and our court members, I would also like to add something on the question of impartiality that my colleague talked about. That's whether the General Court Martial can be impartial on adjudicating of matters before it, and reference was made to Article 28(1). Madam Chairman, my colleague addressed that, but to add something, under Section 207 of the EPDF Act, where rules of procedure and evidence that apply to civil courts can as well be applied to General Court Martial. That is in the law. And Madam Chairman, that goes back to the supremacy of the Constitution. Now, under that Constitution, it provides clearly two things: the impartiality of courts. So it's out of that law that is now 207, it applies to General Court Martial. So what my colleague said, and that article under 128(1) of the Constitution, and 2. So impartiality, really, it is there. This court is impartial. And Madam Chairman, lastly, I wish to also add on what my colleague said, and that is on the procedure, on how you refer a question for interpretation to the Constitutional Court. My Lord Chairman, that one was settled by a Constitutional Court in Ismail Sergo against Kampala City Council. And Justice Wambuzi, as he then was very clear, extremely clear, where he stated that the petition, you can adjust that with the necessary modification, reference must show on the face of it that interpretation of a provision of the Constitution is required. Lord Chairman, what we saw today and the framing of questions was an appeal in disguise. An appeal in disguise. The questions, the way they are framed, we would actually say that the counsel for the accused persons would go under the Court Martial Appeal Court rules through appeal against the ruling that was rendered today morning. Other than think a net that let us see what comes out of the lake. The court does not operate like that, my Chairman, and I pray that you should not allow that to happen in this court. And my Chairman, that was also emphasized recently by the Constitutional Court reference number 31 of 2010. That is Uganda against Francis Atugonza. And court stated that constitutional reference by the court that is determining the cause or a party to the proceedings who request the court, and this goes back to what my colleague and senior Counsel Kalibara stated, that the court, so the hands of court are tied, quite absurd. They are not. That's why you're here. Lord Chairman, that statement itself, it simply puts a constitutional court into a position of applicability of the law, of the rules, which I disagree with my colleague. The Constitutional Court can apply the law in other instances, but as far as constitutional reference is concerned, it's basically interpretation, not applicability. Not applicability. Applicability is with the authority of court. Now, whether the court, I'm not saying this court, whether the court, any court, applies the law irregularly, that is a different matter. And there are channels. You appeal. You appeal. That's what he told me. Now, and lastly, my Lord Chairman, we pray that my Lord Chairman, if I may be protected, unless the law has since changed. But my Lord Chairman, lastly, we pray that from my side, because my senior colleague is going to give it a final push, we pray that you really be pleased with us on the law, and especially where you are dissatisfied with the decision, with the ruling of court, where you are supposed to go. It's okay. And my colleague, my senior colleague, is going to bring this home.
Chairman and court members, I associate myself with my Rand brothers, and I have something to add. In regard to impartiality, when you look at Article 142, appointment of judicial officers, Paragraph 1, the Chief Justice, the Deputy Chief Justice, the Principal Judge, a Justice of Supreme Court, Justice of Appeal, and a Judge of High Court shall be appointed by the President acting on advice of Judicial Service Commission and with approval of Parliament. Now, our honorable colleague tried to dramatize that here you are a judge, you are a complainant, you are so that you cannot get a fair trial before this honorable court. The same person who appoints these justices and judges is the same person when you look at the section 194 of UPDF Act. The same person that appointed the court members, the instrument which you read to the accused person, that is the commander-in-chief, who is the president, and it is the same person. So where is impartiality in that regard? So that one does not require any constitutional interpretation. Please. Section 208 was also attacked of the UPDF Act. I want to implore you to look at section 4 of the Penal Code. Section 4 of the Penal Code Act is about the extent of jurisdiction of courts. And it states the jurisdiction of the courts of Uganda for purposes of this code extends to every place within Uganda. Notwithstanding subsection 1, the courts of Uganda shall have jurisdiction to try offenses created under Section 23, 24, 25, and 26 committed outside Uganda by Uganda citizens or person ordinarily resident in Uganda. For avoidance of doubt, the offenses referred to in subsection committed outside Uganda by Uganda citizens or a person ordinarily resident in Uganda shall be dealt with as if they had been committed in Uganda. And those, under those sections, those offenses are treason and aiding mutiny to police officers, that kind of offenses. And now when you got section 3 of Anti-Terrorism Act, Section 3 of Anti-Terrorism Act, territorial jurisdiction of courts of Uganda in relation to offenses under the Act. The courts of Uganda shall have jurisdiction to try any offense prescribed in this Act, where committed, if the offense is committed in Uganda or outside Uganda. So, it's, the section puts down all circumstances under which the offense can be committed. Then offenses committed outside Uganda, to which this section applies, shall be dealt with as if committed in Uganda. So this section is almost the same wording as section 208 of the UPDF Act, where these officers are asking, where do we get jurisdiction to try an offense which was committed in Kenya, Switzerland? It's not what is special about this. It's not news. What should be interpreted by the Constitutional Court? So jurisdiction extends outside Uganda according to the statute. And we earlier stated that jurisdiction is a creature of statute. Therefore, there is no need for such a section to be referred to the Constitutional Court for interpretation. What would you be interpreting? My Lord Chairman and all court members, we do believe that our land colleagues are aware. They are citing Kabazuguruka case, but they are aware that that case, if you are to implement it, there must be execution. You go and extract execution order. And if you get that order, we would not, this honorable court would be tied. It cannot proceed in trying the civilians. If an execution order, and you know how to get execution order. If you don't know, then you need to go and revise how your criminal procedure. So it would be frustrating. The highest court of the land, I read verbatim how they in the result, we allow application and make the following orders: execution of and or giving effect to the orders and declarations issued by the Constitutional Court in the Constitutional Petition number 45 of 2016 between the parties hereto are stayed until disposal of applicants' intended appeal. Who are you to go against the order of the Supreme Court? Chairman and honorable court members, that is the position of the law. And in case it is not, if we don't proceed, personally, I think I would even be prosecuted to give a reason that we don't have jurisdiction. Chairman and honorable court members, until otherwise, as of now, we have jurisdiction to try civilians. So there is no matter that should be referred again for constitutional interpretation. I submit.
Thank you so much.
Before I take leave, the issue of Kiiza Aaron. The issue of Kiiza Aaron. First of all, it did not arise from the ruling of this court this morning. This was a different matter. Court never made a ruling in regard to Kiiza Aaron, and the court pronounced itself, and it is factus officio. So there is no way how this court can again turn on the same point of law to interpret what happened in that ruling.
Boy Ivan, for the record, and in rejoinder, I'll be brief. The beauty about attending class is that some learn and some do not learn, even when in attendance. Council Kalibala Council Mpanga, Council Kalua, and Council Lukwago went into further detail about the constitutional provisions, the questions vis-a-vis the UPDF Act, and I am disappointed that they might not get a financial benefit to that, but they offered it free of charge for us all to hear and listen. The actual fact that we sit here and says that does not raise a question, that is a question, is the actual reason as to why we should be in the Constitutional Court on such matters pertinent to this matter. I also want to state in general rejoinder that it's not the duty of the prosecution to frame questions that we want the Constitutional Court to address. And nor is it the duty of this Honorable Court, with all due respect, to usurp powers of the Constitutional Court under 137 to interpret questions posed by the parties. I also want to state unequivocally that there are two legs within the Constitutional Court. If it may please you, I will substantiate on the two legs. On the two legs, there is one where the court deems it fit to raise a constitutional question. That is one leg. And in the wording of the Constitution, they use the word may. I believe that you as officers of the UPDF understand command, order, and all that. The second leg of that Constitution, Article 137, 5B, gives latitude to the parties to escape the tyranny of a court, tribunal, or a disciplinary committee by allowing the parties to pose a constitutional question. And we didn't move under the other leg one. We used leg two to protect and defend the rights of the accused persons. And that leg in the Constitution, it says shall. It is coiled in mandatory terms. The Supreme Court has been in position to guide in a number of authorities about the coiling of the Constitution and the word shall and may. And the framers of the Constitution, of which Dr. Besije, one of the accused person was, is very clear and instructive. So it's our duty to ask that the professional UPDF under Article 208, the professional and professional soldiers should respect the command and the supremacy of the Constitution, of which we are all here to defend. Members of the General Court Martial, I also want to mention that when the prosecution wants to phrase its own questions, it shall present them before the Constitutional Court. We have framed ours, and we are saying this matter warrants a constitutional interpretation. Members of the tribunal, I do not understand the obsession with the Kabazukuka case. My senior has already alluded. I said the General Court Martial, tribunal, or any disciplinary committee. And with the word court, if it appeases your ears, I shall maintain that. Professionalism means respect to the rule of law. None of you will be hurt, or there is nothing for you to lose if you refer our questions to the Constitutional Court. And in the way, counsel lied to this honorable court by saying that this court's hands are not tied. Actually, they are tied with chain and shackles. And I'll address in broader perspective about the MOU you talked about. That MOU is alien to us, and it's not anywhere within our knowledge. All that we are so sure of, Article 79 of the Constitution only gives powers to Parliament to make laws, and also has a condition that no one else can make laws that have force in Uganda. Whoever that MOU might have had his own wishful desires, and that's not our problem. Our problem is that the law of the land must be enforced the way it is to the latter. And also, in the most severe, I want court to take judicial notice under the Evidence Act, as taught by Senior Kalibala, that even in the most cases of Jamil Mukulu, there was an extradition from Tanzania. As to whether the accused person did not enjoy that benefit is also another phenomenon we are about to explore. I also want to state that the issue of impartiality has been largely misunderstood by my colleagues. It's not about the members of the court. No, it's about structural issues rooted in the UPDF Act vis-a-vis the Constitution of the Republic of Uganda. We do not have any desire to impute the credibility of the members of the panel, and we have less appetite for that detail. I also want to state that, having said so, these are our questions as to whether they desire to make submissions challenging any of the interpretation. Unfortunately, none is qualified. None of us is qualified to authoritatively do that, save from the Constitutional Court. And trying to do that is violating and usurping the powers of the Constitutional Court and molesting and defiling the Constitution of this Republic. The idea that we court covers Guruka and leave other cases that have been decided and not appealed is appalling, and should be the duty of the officers of the UPDF to maintain the stature or the desire for the UPDF to be a professional army. And finally, when a matter arises, when a constitutional matter arises, it has to be referred for interpretation. Otherwise, again I state, none of us is qualified to interpret the Constitution. And another rider is failure to respect the interpretation of the Supreme Court, also tantamount to violation, molesting, raping, defiling, and abrogation of the Constitution of the Republic of Uganda. We desire, it's our desire, that we do not want the UPDF and its institutions, most especially the General Court Martial, to treat and trend that way. Again, we do not know about that MOU being quoted. We do not know it as under the laws of Uganda. We also we are certain that it did not conform to Article 91 of the Constitution of the Republic of Uganda, and whoever made it can as good as use it to light a fire and a charcoal stove for their own benefit. Thank you so much.
Honorable Chair, the panelists, and members of this court, I want also to take this latitude to add on my voice as the defense team for Dr. Kiiza and Abed Mutale. It is quite very paradoxical, outrageous for prosecution to allege or to assume jurisdiction that this court has jurisdiction in interpret questions which we had raised. Whereas we take recognition of the fact that the Constitution of the Republic of Uganda ushered in this very general court martial to discipline or to handle cases regarding the disciplinary of military. It is not true that because by virtue of that very enabling provision of the Constitution that you have jurisdiction to interpret these questions. I would love to implore this court to adopt this decision while the Constitutional Court was faced with the same similar matter in the case of Honorable Sam Kutesa and two others versus Attorney General, which we had prior in the morning while submitting on the same, was submitted by the defense team, that is by Counsel Kalivala. The House of Lords in this case, while elucidating on these facts, we are able to persuasively adopt the decision in Namibian case of State versus Cherison, 1991, volume 20 SA, at page 813. And it was to the effect that the Constitution, this is the catching word, the Constitution of a nation is not simply a statute, which mechanically defines the structures of the government and the relationship of the government and the governed. Those are the few catching words. It is a mirror of reflection. When you go to a mirror and you put in front of you, you can ably see what is happening on you. So this is a mirror of reflection, reflecting the national soul of the identification and the ideas and the aspirations of a nation, the articulation of the values bounding its people and disciplining its government. In summary, therefore, as I invite this honorable court to adopt, and they should respectively adopt these decisions. These decisions act as jurisprudence. They are binding precedents. This is a decision from the Constitutional Court. This is what the House of Lords had to say, that in interpreting the Constitution, that's why I'm differing from the view of my land friends. They are trying to hoodwink and mislead this honorable court, which we totally disregard. That in interpreting the Constitution, the rule of harmony and completeness requires that constitutional provisions should, the word is should, not be looked in isolation, but rather the Constitution should be looked as a whole document. That's why it is because of the Constitution is referred to as the grand norm. Article 2, Clause 2 of the Constitution is very clear. If any law is inconsistent, is repugnant, any regulation, including the ones which this General Court Martial is citing, if it is inconsistent, it is contrary to the provisions of Article 2, Clause 2. The framers and the promulgation of that very article were alive to the fact that certain issues arising out of during proceedings like similar one might arise. That if any law, if any regulation which is in consistence with that very particular article, it should be declared null and void. And it is because of that very same article that we are trying to invoke Article 137 to enable us to refer this matter for reference. So it is misleading and it is quite very paradoxical. I humbly request that this honorable court to disassociate the submission of the prosecution. They have miserably failed at any stake with any iota of evidence to prove their case. I so pray.
Honorable Chair and honorable members, I am grateful to my land friends on the other side, because in my view they have not dealt with any of the issues that we raised, and I am grateful that they have made our work a little easier. We are past the stage in this country where we should have mechanical responses to legal issues. To just say no because I can say no. I think I should say no because there is value in the position that I have adopted. I have listened carefully to what my land friends have said, and a lot of it sounds to me like the arguments we will invite them to make when we go, hopefully, when we are referred to the Constitutional Court. Because those arguments will be very important in that court as it interprets the articles that we have cited. Honorable Chair, we did say in our submissions initially that the questions around impartiality have nothing to do with the fine members who are in this court. It's not personal. We have no doubt that the gentlemen and lady officers who are in this court are fine gentlemen. But I said gentlemen and ladies, but the regulations we cited, they are laws, they are not individuals. I appreciate fully the idea that the High Command and the General Court Martial have different roles, administrative and otherwise. But I read a rule which says that the High Command can be consulted on matters of law. I haven't heard, I think it is 69, I haven't heard a response that says it can't. If we take it to the other side where we are used to appearing, there is no similar provision where a judicial officer, also appointed by the president, can consult the appointing authority. It doesn't sit comfortably with the idea of impartiality. So it's an institutional issue, it's not a personal issue. It has nothing to do with the gentlemen before whom and the ladies before whom we are appearing in these proceedings. Honorable Chair and honorable members, we treasure the Constitution, as I am sure you do, because it's the only one that equalizes all of us. It's the only one where everybody can look and say, I am equal to this one, I'm equal to that one, in that document. So we find it uncomfortable when some of these things are trivialized, especially where they have to do with the Constitution. This is not a petition that we are asking to be made, this is a reference. There is a reason why we have a difference between petitions and references. And what I honestly expected my land friends to do was to enrich the questions so that we go together and come back together better enriched, knowing where everybody can trade so that we are not walking on eggshells, nobody is walking on glass, nobody is afraid. That's what I expected, that they would come and say, the phraseology is not proper. Honorable Chair, this is a better phraseology, because that appears to us to be what must happen when Article 137(5)(b) is invoked. So I would invite the Honorable Court to consider those questions as posed, and perhaps to also just put another small matter to rest. The question of how you refer. There has been reference made to rules on petitions and references. That is the stage we will get to when the reference is being made, because there is a formal document. It would be presumptuous of us to phrase the questions and then just thrust them in the face of the court. We would have been hoping that we would have agreed together with my land friends so that we focus on what the court will submit. The questions that we posed were our proposals. We thought they covered the necessary ground. My brothers on the other side can enrich them. In fact, I invite them to do so. So that when they are leaving the court, we are in agreement about what those questions are. We are not debating at all the power of the appointing authority. The appointing authority appoints many people. But if an ambassador were appointed and is allowed to exercise judicial power, we would argue the same things that we are arguing today. Although they were appointed by the same. If an RDC attempted to exercise judicial power, are also appointed by, we would argue the same things. We are just dealing with matters of rule of law. They affect all of us. They are for the benefit of all of us. Today, tomorrow, in the future. So we shouldn't deal with them lightly. They are serious. Lastly, my land friend Colonel Brigadier Raphael knows that constitutional interpretation is a matter in rem. It's not in persona. It is in rem. Once the court says A, it has said A. Only a superior court can unsay A. We have cited before you a number of authorities where the court which interprets the Constitution has consistently, in fact, in one of the cases, they just said we adopt the other views and we transplant them. Consistent. There is no other interpretation. We have one, only one. And we must abide. If indeed we are subordinate to civilian authority, we must abide by that interpretation until there is another interpretation. So there is no stay for Semoju, there is no stay for Captain Yarugaba. I am not sure why. Uganda Law Society that was referred to was confirmed. The position is clear. And I invite you very respectfully to appreciate that position and to do the right thing and send us where we can settle these questions. They will benefit us here in this case, they will benefit other cases, they will benefit the future. We will have clarity. This is about all of us, every one of us in this room, every one of us must go home comfortable in the knowledge that we know what the law says. Because again, in this jurisdiction, there is only one person who cannot be subjected to these types of processes. Only the sitting head of state. Everybody else, without exception. I thank you, Honorable Chair, and I thank you, Honorable Members. My land friend wants to close.
Thank you, Chair. Briefly, one, that the issue of Aaron Kiiza did not arise in today's proceedings. It's neither here nor there. Chair and members, the constitutional reference is not only about today's ruling. It's about the proceedings right from the beginning. Right from the very moment charges were read before them, and also the rulings that were made that you have jurisdiction. It's a whole package. So is misconstruing the context of this petition, rather request for a reference, all the proceedings we have had. So it cuts across. The other thing is about the East African Treaty, the MOU. He they made some submission here which is really disturbing, that your ruling is settled it all, that is final. That you are the alpha and omega on interpretation of the Constitution. Is this an appellate court? That is not really the position of the law. We take exception to that. It's outrageous, and it's not also an appeal to the court martial appeal court that this is an attempt to appeal. No, it's very clear, grounded under the constitutional provisions. On the question of the Supreme Court, they said they are decisions of the Supreme Court. The order of state specifically in Kabaziguruka. I want to address you on this. 5th of August 2021. And the decisions we made reference to of Semuju and Amon Byarugaba reaffirming the Kabaziguruka position of 2022. So this order is not applicable. And I want us to put it in context, Mr. Chairman. I have a copy here. They are consequential orders that were given, that all files pending before the General Court Martial be transferred to the civil courts. That was the consequential order which was stayed, not the interpretation. And it's the reason he advanced the argument that a decision of the Constitutional Court is in rem, is not in persona. So the consequential order is the one that was stayed. But the Constitutional Court has been consistent that the interpretation about the jurisdiction has not been overturned. If anything, it has been reinforced by the recent Supreme Court decision in the case of Ogwang versus Uganda. If I may just read one aspect of it, it's very, very important and instructive, Mr. Chairman, so that it's the only Supreme Court decision we have, the only one on this. And no misconstruction should be made to say that the Supreme Court has got any other order as far as the jurisdiction is concerned. As they are getting it for me, allow me also refer you to the submission on the applicability of the Firearms Act. Mr. Chairman and the honorable members, the Semuju case is very, very clear. It's very, very clear. The General Court Martial's jurisdiction is only limited to trying service offenses specified under the UPDF Act, only in respect to persons subject to military law. Offenses under the UPDF Act. Military law under the UPDF Act must be construed to exclude laws that are the preserve of civil courts. This has not been set aside. This has not been subjected to any other interpretation. So where do they derive that argument that this honorable court is clothed with jurisdiction to handle matters under the Firearms Act? So the East African Treaty, I want to talk about it. The MOU and the East African Treaty. They were again misinterpreting this decision of Omar Awad. Omar Awad, the extract they were making, the extract they made is very clear. They were talking about repatriation of fugitive offenders. And when you look at the Extradition Act, a fugitive offender is defined. A person having committed an offense, you run away from the jurisdiction. And again, in this particular case, you find the case, facts, you read the facts. In Tanzania, for example, where these people were repatriated from, there were extradition proceedings, only that they did not wait for the appeal. So this East African Treaty did not in any way purport to outlaw the Extradition Act or in any way to repeal it. let me use that word. The treaty did not repeal the Extradition Act. It is still good law, and it must be complied with. So an MOU made under the treaty, which is also subject to question because we have not seen it, cannot be said to be within the parameters of the extradition law. Now, to emphasize the other point, Mr. Chairman, I want to just read that extract from Ogwang. In our view, the body of the UPDF Act specifically sets out the army courts as a parallel judicial framework, distinct and juxtaposed against the courts of judicature. It appears to have been contemplated that the UPDF courts were better placed to address the discipline issues within the rank and file of the armed soldiers, and better able to hand out penal sanctions, that hopefully deter further offending. It is through these structures that UPDF soldiers are made accountable. And they concluded by indicating that the Constitution of the Republic of Uganda, which gives Parliament authority to make such laws as provided for under the relevant provisions, deemed it necessary to create a disciplinary court. They emphasize a disciplinary court for the members, the rank and file of the UPDF and members of the UPDF. So this reinforces the position given by the Constitutional Court that the jurisdiction of this honorable court is restricted to those matters which are within the UPDF Act and not any other law. That is the latest decision in Ogwang. Now, finally, the issue of the issue of the procedure. Mr. Chairman, this issue of procedure, the procedure to follow here is very, very clear. Once you move court for a reference, the questions are formed, are raised. They are framed. The questions are framed. So we are at a stage of raising these matters for purposes of framing the questions. And this is important. So I don't know how else they wanted this to be done. And this has been the practice all through, that you raise the questions, you raise issues, and then the questions are framed. So they can't fault us on the procedure we have adopted. Allow me invite the Council Fred to add 1-2 submissions, then we'll wrap up.